Good afternoon, everyone. Can you all hear me? Thank you all for coming. We're very excited about today's talk. I just want to alert everyone that this is the last day of Animal Law Week, so thank you to everyone who's made it to every single session. Today's session, we have Elizabeth Forsyth, who is a senior attorney at the Earthjustice, and Shashank will be introducing Elizabeth, but we're so excited to hear. All these slides will be up on our website, so please check that out. Okay.
Thank you all for being here. My name is Shashank, and I'm a Creole and one of the current co-presidents of the Animal Law Society. I will be a wildlife lawyer after graduation, and one of the people who inspired me to pursue that line of work was Elizabeth Forsyth. In 1L Fall, she was here as a Wasserstein Fellow from OBIA discussing public interest lawyering, and that's when I learned how powerful a tool the Endangered Species Act can be. So we're really fortunate to have Elizabeth here. Elizabeth is an HLS alum. She graduated in 2011, and then clerked for a year in the Western District of Washington, then finished a 2-year Beagle Fellowship with NRDC through Harvard, and then joined Earthjustice in their California regional office before becoming one of the founding attorneys at the Biodiversity Defense Program. So please give a round of applause for Elizabeth.
Thank you so much for having me back. And can everyone hear me if I go stand? Okay, great. I'm back in part because I like coming back to law school. I like being a law student. I'm here to try to inspire everyone in this room to consider a career at someplace like Earthjustice, using the law to help species, to help the environment. And so my talk today is aimed at the sort of law student level. I'm going to give a basic overview of the Endangered Species Act and what we do at Earthjustice and how we use the Endangered Species Act for wild animal protection. And this first slide here actually shows the five critters that I'm going to discuss. This is the salmon in the Pacific Northwest, grizzly bears in Montana, Pacific fisher in the Sierras, Mexican wolves in Arizona, New Mexico, and the Florida manatee. So these species sort of span the country, and I'm going to kind of give an overview of all of them. This is a map of Earthjustice's offices. I have Earthjustice swag here for those of you that are interested. We are about 200 attorneys. We have 15 regional offices across the country. So if you're interested in this work, think about us for your summer internship. We also do term-time externships, which I understand is a possibility perhaps. So think about it. We're everywhere you would maybe want to work, and we're looking for young minds like yourselves. These little stars. Again, I'm going to talk about these 5 species. These are where they're located. It just gives you kind of a sense of the breadth of the work across the country. We're really everywhere that wild animals need protection. This is where we're working. So in my talk today, I'm going to try to give, in 40-ish minutes, an overview of the ESA and the major sections that, as a public interest nonprofit practitioner, we work under. So just to give you, can I get a raise of hands of folks who have a little bit of basic knowledge about the ESA? Okay, so that's perfect. The Endangered Species Act is our nation's premier wildlife statute. It's unique. Most wildlife regulation prior to the ESA really had to do with how do people use wild animals, about hunting and fishing and regulating that for people's use. If folks went to first year property, which I think most of you have, Pearson v. Post, right? Who owns the animal that you shot? The ESA is unique here because it is allowing for species protection for species protection's sake. And I actually love this language from the preamble, that it's finding that harm to species is a consequence of economic growth and development untempered by adequate concern and conservation. This is really a conservation and protection-minded statute. It's got 10 parts. This is just a basic overview. And the most important provision here for us as practitioners is section 11G. I said 10 parts, it starts with part 2 for some reason, so that's why there's part 11. And this provision allows any person, so me on behalf of my clients and my clients with me representing them, to, and these are the two major provisions we use, to commence a civil suit to enjoin any person, and person can mean corporation, it can mean government, who is alleged to be in violation of this chapter, or against the Secretary, and the Secretary here means Secretary of Interior or Secretary of Commerce. Functionally, this really means Fish and Wildlife Service or the National Marine Fisheries Service, the wildlife agencies with jurisdiction over threatened and endangered species. So against the Secretary, where we can allege that the Secretary or these wildlife agencies have failed to perform a responsibility under the Act that is not discretionary. So just a roadmap of the various sections I'm going to talk about and the case studies I'm going to use. Section 4 is how you get on the list, and then I'm also going to talk about recovery plans under the ESA. Section 7 is federal agency responsibilities and interagency cooperation to ensure that federal agency actions don't harm threatened and endangered species. And then finally, I'm going to talk about the Section 9 take provision, which is probably the most powerful part of the Act that can enjoin any person from actually harming threatened or endangered species. So I'm going to start with talking about Section 4 listing. How do you get on the Endangered Species Act list? There are 5 factors: destruction of habitat, overutilization, disease incubation, inadequate existing regulatory mechanisms. That means that the state that the critter is in isn't adequately protecting it. And then any other factor that is harming the threatened or endangered species. This listing of a species has to be based on the best available science, and to take a species off the list also has to be based on best available science. So it's quite protected in that we don't consider costs or economic considerations when we put a species on the list. We only consider the ways in which it's threatened. So I'm going to start by talking about the Pacific fisher as a case study. All of these cases, by the way, I picked because they're cases that I've worked on, and so I think it's a nice way to sort of say, as someone who's looking at a career, these are things that you could also work on. But I want to start actually by talking about the northern spotted owl. So in the 1990s, Earthjustice and our clients in the Pacific Northwest got the northern spotted owl listed on the Endangered Species Act list. And as a result, the northern spotted owl, for folks who may not be familiar, needs old growth forests. And at the time, these forests in the Northwest were being widespread clear cut. And the listing of the northern spotted owl and its subsequent protection under the ESA resulted in old growth forests being protected in the Northwest. So Earthjustice in the late 90s, on behalf of our clients in California, said, can we do something similar in the Sierra Nevada? And they started a petition to list 4 Sierra Nevada species: the yellow-legged frog, the Pacific fisher, the California spotted owl, and, sorry, the mountain yellow-legged frog, and the Yosemite toad, which all represented sort of different ecosystems in the Sierra Nevada that we wanted to protect. So, to try to protect habitat in the same way that listing the northern spotted owl worked in the Pacific Northwest. And I'm going to go through sort of the history of this to sort of say these are not necessarily short and easy fights to get a species listed and their habitat protected. I have a good friend from law school who said, you fight until you win, and if you haven't won, then you're not done fighting. This is a good indication of that. So the petition, you can petition to list a species. The petition was filed in 2000. Then there was a lawsuit when Fish and Wildlife Service didn't respond to the petition. Finally, that lawsuit settled. They made a determination that listing is warranted, but they just don't have time yet. They're getting to other species first. That's a thing you can do under the Act, for better or worse. There was another lawsuit in 2020 to compel them to make a final determination. Finally, in 2014, it felt like we were getting progress. The service issued a proposed rule to list the fisher as threatened based on numerous threats like habitat loss, illegal rodenticides in their habitat that were killing the fisher, small population size. And then in 2016, rather than finalize that rule, the service withdrew it. We filed a lawsuit in 2016 over that withdrawal. In 2018, we got a court order saying service acted arbitrarily and capriciously in dismissing these threats to the fisher. And in 2020, the service listed the fisher as endangered in the Southern Sierra. So this map shows the fisher has two populations, one in the north and one in the south. Listed the south portion as endangered and said, the northern portion is fine. Again, there was another lawsuit in 2022 to try to make sure that the top portion of the fisher habitat is protected as well. As a result of that, there's now a 2025 deadline to make a new determination for that section. So these are very long fights in some instances, and it's still not completely over for the fisher, although at least for some of it is now protected as endangered. So moving on now so once you've got the species list on the Endangered Species Act list, a provision for recovery planning kicks in. It's one of the benefits of being on the list is now you have to figure out how to get the species off the list. So I'm going to give a little bit of an overview about litigation over recovery plans and how the recovery planning process works. So recovery plans are under Section 4F. It says that the Secretary, again, this is Fish and Wildlife Service or National Fisheries Service, shall develop recovery plans for conservation and survival of endangered and threatened species, and incorporate into the plan site-specific management actions necessary to get this, to help the species. And this is a long sentence that's objective measurable criteria, which when met would result in a determination in accordance with the provisions of this section that the species be removed from the list. So this means the target to say, okay, at this point when the species has hit, this population or we've solved these threats, then it can be removed. So it's a roadmap. It's an important document for management of the species. So this brings me to the Mexican wolf. So why do we care about the Mexican wolf? The Mexican wolf is one of the most imperiled mammals in the country. It was completely eliminated from the wild in predator control efforts at the turn of the century. It was reduced to 7 captive bred members. This is an image of one of the captive bred wolves at the Living Desert Museum in Palm Springs. And so you can imagine if you have 7 wolves, that genetics of the population is very poor. The amount of management and breeding and releasing into the wild that has to happen is quite a feat. And so the recovery plan matters a lot because trying to figure out how you get from 7 to a robust population is complicated. Now, I want to start out by saying our scientists have said in order to have a recovered population, you've got to have at least 3 populations of wolves of about 200 members each with a meta population of 750 wolves. That would be enough to deal with the genetic poverty problems and to have a self-sustaining population. So in 1982, Fish and Wildlife Service released a recovery plan, but this plan did not set a recovery target at all. And so Earthjustice, along with our partners, sued in 2015, saying that that's not a lawful recovery plan. You don't actually have a target. You haven't said what it will take to get this species delisted. That suit settled. The service issued a new recovery plan in 2017. Oops. And this recovery plan failed to set a target that would actually result in the conservation and survival of the Mexican wolf because instead of a 750 population, it set a target for, I think it was something like 320 wolves in the wild. And that 320 target had actually also been struck down by a court. This gets a little bit outside of the talk, but there's also a experimental population provision under Section 10J of the Endangered Species Act. That section, the Mexican wolf is an experimental population because it was bred into captivity and then put out into the wild. That 10J management rule also set a 320 target. The court said that's arbitrary and capricious. So we felt like the recovery plan should also set a more robust target. The district court said no, as a matter of law, this is not something that you can challenge. You cannot challenge whether a plan provides for conservation survival because that's not a non-discretionary duty enforceable by the ESA. I want to put a pin in that because I disagree with it, but I also want to say that the judge let us go forward with another claim, which was that the plan did not adequately deal with the frontline threat to Mexican wolves, which was illegal killing. So farmers, ranchers aren't necessarily big fans of wolves. They were being shot and killed, are still being shot and killed in large numbers, threatening recovery. And so we said this plan doesn't deal with that. The judge agreed with that claim. We ended up winning on that claim. And then the Fish and Wildlife Service went back, revised the plan. Meanwhile, we went up to the Court of Appeal. That's the oral argument that you got to see. And the service had released a new revised recovery plan in the interim, and the Ninth Circuit, rather than reaching this really crucial question of can you challenge recovery plans for failure to actually provide for conservation survival, dinged it and just said, you know, you've got a new plan here, this case is moot. So this is a kind of example. Recovery plans are important documents. I hope that this claim lives to see another day in the Court of Appeal. The district courts are split on it. So this is kind of an example of, if you get into this kind of work, the kinds of legal issues, you know, maybe you'll take up to the next round and see if you can get some traction on. And meanwhile, we have gone back and challenged again a revised 10J rule that, like the old 10J rule, does not set a management target that will actually provide for conservation survival. So our work on Mexican wolves lives on. All right, I'm going to move to section 7. Let's see, I'm actually doing quite well on time. So section 7 is the consultation provision of the Endangered Species Act. So this section requires that each federal agency that has an action, either that they fund, authorize, carry out, so this is anything that's approved on public lands, anything that the federal government is funding. It includes rules and regulations that a federal agency might issue. They have to make sure that these federal actions don't jeopardize the continued existence of a threatened or endangered species. Jeopardize means engaging in an action that would be expected directly or indirectly to reduce appreciably the likelihood of survival or recovery of the species. And the way that they do this is through consultation with the applicable wildlife management agency, again, Fish and Wildlife Service or National Marine Fisheries Service. The consulting agency writes a biological opinion that says, you know, usually this action won't jeopardize the species if you put into place these management measures. And the important part about this is we can challenge those biological opinions if they are arbitrary and capricious. And for those of you in the room who have not taken admin law, this is the sort of basic agency review of agency action has to be not arbitrary and capricious. If you haven't taken an admin law and you want to do any environmental work, please take admin law. So I'm going to give a case study here of a proposed mine in the Cabinet Mountains, Montana. I'm going to play a video that features our client because I think he and the scientists in this video give a better overview of what's at stake than I can. Let's see if this will work.
I was told as a young man that this is a sacred place. I grew up in the Tanaka territory. The Cabinet Mountains represents to me my soul, my heart. This is where we practice what you call our religion. I call it my cultural spirit. That's where I go practice.
My wife Kathy and I came about 43 years ago. We were in our 20s, we were young, idealistic, pretty broke, didn't have a lot of money. We started a sawmill business, and that allowed us to make a livelihood. you're really immersed in the mountains and you really feel that you're part of them. That's something that attracted me to this area, many years ago. The beauty of a wilderness area is that you leave it alone.
The grizzly bear, they were here before we were. This is their living room. This is their backyard.
The Cabinet-Yaak population is probably, is in fact, the smallest and most vulnerable of the populations that we currently have in the lower 48 states. They are acutely vulnerable to any sort of change in their environment. So it makes no sense to argue, as the mine has argued, that we can increase levels of human activity in their environment and not expect them to be negatively affected.
Hecla is a new player in Montana. They've come into our community and they've said, trust us. Can you trust them?
Greed over beauty. To make somebody else rich.
The risk is just too great. We have a chance here in the cabinets to keep what we've got.
So I've been told online I can't be heard, so I'm gonna stand a little closer to the microphone. So this is, I was involved in challenging the Rock Creek mine. As you can see, there's a nearby proposed Montnor mine. Both of these proposed mines would bring industrial development to this sort of pristine area that is the home of one of the smallest and most fragile grizzly bear populations, and also important habitat for threatened bull trout. And I put this slide up. It goes back to the theme of you fight until you win, and you haven't won, you've not done fighting. You're not supposed to be able to read all the text on the screen. Each of the dark parts is a case dating back to 1993. That's how long Earthjustice and our clients have been fighting these two mines. And I was only involved in the most recent round on Rock Creek. There we challenged the biological opinion based on a deficiency that the court had previously found on a case challenging the nearby Montnor mine's biological opinion. And we said, look, it's got the same problem. It also has to be overturned. Rather than fix that problem, which the agency instead said, okay, we're actually just gonna look at the exploration phase of the mine. We're gonna cut all the rest out of the biop, anything to do with mine exploration. We immediately said to the court, that's not a lawful course of action. You can't kind of put your ostrich head in the sand to what this full mine build out is going to look like. The court agreed, held that the biological opinion for just the first phase of the mine was invalid, and therefore the approval of the first phase of the mine was invalid. We got that opinion in 2021. I haven't heard anything more from the mine developer or whether there's going to be a new biop on the horizon, which just says, for right now, we're not fighting, but given the litigation history, we'll be there for the next round if there is one. I'm going to turn now to reinitiation of consultation. This is another hook. Once you have something approved by an agency, if there is continuing involvement or control over the action, and I'm highlighting the provision that we used here. If there's new information that reveals the effects of the action that they maybe didn't consider before, you can ask them to go and reinitiate consultation. So this is a provision that we used for Florida and the manatee die-off. This is Florida's waterways. This is not supposed to be this color. Florida has real problems with nutrient pollution from nitrogen and phosphorus that when it gets in the waterways creates algal blooms that causes seagrass to die. And I'm gonna play another little video that just gives an overview of the problem again. This is a manatee statistic in 2021. Because of the seagrass die-off, we lost a huge percentage of the Florida manatee population in a single year. It's now been, I think, something like 21% of Florida manatees have been lost since 2021. And I'll play the video if I can. Yeah.
They're such wonderful animals, and they're so docile. They'll just come right up to you. They just have wonderful personalities. And to find dead manatee on my tour is pretty devastating. I want to cry.
Everybody was sharing this common sadness of, what's going on with our estuary, that it could be so severe that our manatees, are starving to death, where typically we would have meadows and meadows of emerald green seagrasses. Because the seagrasses are disappearing, all of the animals that rely on them, like the turtles and the fish and the manatees and everything.
Here, sorry, I hit a button by mistake.
Thing that would eat the seagrass, we're losing them. They're dying of starvation.
It's like when you go in the emergency room and the doctors want to figure out what's wrong with you, they slap monitors all over you. That's what we're doing for the Indian River Lagoon. We're monitoring its life support machinery to figure out what's going wrong and how we can repair it.
All of these pollutant sources add nitrogen and phosphorus into the lagoon. The nitrogen and phosphorus fuel harmful algal outbreaks, and that shades the seagrass, causing it to die, and then now the manatees are starving to death.
It's a little over 20% of the East Coast population that's been decimated in 2 years.
So what we were looking at with our partners was, well, how do you control this nutrient pollution?
You can't deal with the pollution after it gets into the lagoon. It's like taking cream out of your coffee.
This pollution is preventable, right? This is all human-caused pollution. This is from your septic tank, it's from our wastewater treatment plant, it's from agricultural runoff, it's from fertilizer in your yards. So this is all pollution that is preventable, can be regulated, can be reined in.
Obviously, reducing that pollution at the source is going to be the first step.
What we're hoping for is, the expert federal agencies to get together and to assess what pollution standards and controls do you need in place to make sure that you don't have so much nutrient pollution that all the manatees died.
What we're standing next to is a comprehensive treatment system to remove pollutants from water that comes from the drainage canals and some of the treatment facilities in Indian River County. You see the water here is very clean, no algae, and a lot of fish life and a lot of wildlife.
The only way to solve the problem of manatees starving to death is to bring back their habitat, the ecosystem that they rely on, the seagrasses that they eat.
They're a beautiful animal, and they were here long before us, so we should make darn sure we keep them here.
Skip through these slides, which are my seagrass slides in case my video didn't work, to just end by saying, so we focused on reinitiation and consultation here because what we think is the root of the problem is failure to rein in nutrient pollution. So EPA is the federal agency that approves water quality standards and measures to prevent those standards from being exceeded. It approved Florida's standards in 2013 in consultation with Fish and Wildlife Service, which is the expert federal agency that oversees manatees. And both agencies agreed these standards are going to protect manatees, they're going to repair their habitat, and everything's going to be roses. Well, in 2021, it was not roses. We had a mass manatee die-off. So we used that reinitiation of consultation provision to say, there's new information here that shows that your standards and your means of meeting those standards are not adequate, and they need to be revisited. So we filed that lawsuit a couple of years ago, and we've been waiting almost a year for a ruling from the court. So this is a stay tuned. And hopefully we'll have a favorable result. But this is just an example of the kind of litigation that we can bring to get at something that's not necessarily just about the animal, but about the whole ecosystem and about the pollution that enters it. All right, I'm down to I can't believe I've been able to make it through all these provisions of the ESA in less than an hour, and I'm down to my final ESA provision, which is Section 9, and it is my favorite. This is the hammer of the tools in the toolbox. And I'm just gonna, I wonder if there's a way to take off this little set up professional audio. So that you can see my slides. All right, there we go. So Section 9 prohibits take of endangered species, and take is defined as harass, harm, pursue, hunt, shoot, wound, kill, trap, capture, or collect, or attempt to engage in any such conduct. Congress put so many words in there to really try to make it broad, to say, whatever you do that's going to harm an endangered species, we say no to that. And under Section 4D, wildlife agencies can extend this take prohibition to threatened species. By statute, it only applies to endangered species, but they can extend it to threatened. And for the most part, they have for the species at issue in this case I'm going to talk about. And this is a picture of bull trout and an illustration of Chinook salmon, both which are listed as threatened in the Pacific Northwest, where I'm going to talk about. Fish are managed a little bit funny, where the different subpopulations that interbreed are all listed separately as species. This is a thing that you can do under the ESA. It's not just covering species, but actually distinct population segments or interbreeding groups of species. And this is a case, oh gosh, I don't know how to get this little taskbar, but it says Section 9, case study, the Electron Dam. So this is a dam that was built in 1904. When it was built, it spanned the entire Puyallup River. The owner of the dam in 2020 wanted to remove half of the dam. The part that's not wooden is the part that they wanted to remove, to build a new kind of inflatable bladder dam. And in doing so, when they rerouted the river to construct the dam, they laid a bunch of toxic tire crumb rubber in the river and then a liner, which immediately all washed downstream. And they got stop work orders that stopped them from finishing their construction. They erected this temporary sheet pile wall rock dam, which is the part that is not wooden in the picture. And we represent the Puyallup Tribe of Indians. The Puyallup Tribe brought suit, and in 2021, under the ESA Section 9, the court, first of all, ordered the dam operator to stop sucking water through their intake. So above this, in the picture, there's an intake that takes water downstream. And when it sucks water in, it also sucks fish in. Fish were routinely dying this way in the intake. So the court has preliminarily enjoined the intake. And then in 2024, we brought a summary judgment motion that said this rock dam sheet pile, which you can see there, is a take for migrating species because they are actually attracted to the rock dam and away from the fish ladder, so it's blocking and impeding their migration. And the court ordered that this temporary rock dam needs to be removed this summer. This is currently on appeal and all sorts of motions practice going on, so it's not out yet, but it shows you what a court can do under the Endangered Species Act, Section 9, to not only stop, taking water out of the river, but actually say you've got an impediment that needs to be actually removed here. And that actually brings me to the end of my slides. I want to say one sort of final parting thought about the ESA, which is it's our most powerful tool. We work under all the tools at Earthjustice. I've probably litigated all the acronyms, TSCA, FIFRA, Clean Water Act, Clean Air Act, Magnuson-Stevens Act, all of the environmental statutes. But it remains our most powerful because it is the statute that is really focused on preventing harm to threatened and endangered species. That being said, because it only deals with species once they're at their breaking point, it's got a real gap in that it's not an ecosystem protection law that works everywhere. You have to have a listed species, and if you're using Section 7, you have to have a federal hook. So if I were writing a new law, and maybe you all will be in Congress or in state legislature someday and thinking about this, I'd love a law that doesn't wait until you're hanging by a thread to protect species or ecosystems. If we had ecosystem protection law, that would be fabulous. If somebody in this room could go do that, I'll help you litigate it later. And I think that's my concluding thoughts. I'm happy to take questions.
Yeah, well. Thanks so much again, Elizabeth. And we have some time for questions. So if anyone in the audience has a question for Elizabeth related to the Endangered Species Act, environmental law, animal law, or public interest lawyering in general, or anything else, please feel free to ask. Oh, yes.
I was wondering what your thoughts are about the reason you try to use the Endangered Species Act to target like the mifepristone rule.
I'm not aware of that.
Oh, it's really interesting. They're trying to like use the Endangered Species Act consultation obligations to say that the FDA didn't properly consult when they adopted the mifepristone rule.
Oh, no comment. That's not how I would use the statute.
For context, my understanding is is that an abortion drug? Yeah. So I think, yeah, it's a very cynical use of the Endangered Species Act for purposes that the ESA wasn't enacted for. So, yeah. And and I think the court will probably dismiss it. Oh, there's a question here.
I wanted to thank you, first of all, for coming. This has been interesting. I wanted to pick up on sort of your closing point about, new statutes, new frameworks, because it's been a long time, and the ESA is a unique statute for all the reasons you mentioned. So I guess I'm asking you to do some of the stuff you're asking us to do, but what do you think, why has it been so long, given what I think are positive developments in our moral frameworks and how people think about it, but the rest of the code still sees animals as a purely economic benefit or loss in their value. So what do you think is keeping us from moving forward, and what can we do to change that?
Congress. I mean, we had this wonderful moment in the 70s where we passed all these groundbreaking environmental statutes. The Endangered Species Act, NEPA, Clean Water Act, Clean Air Act were all passed around the same time. And there hasn't been major federal legislation like that since. I mean, we had 2016 TSCA amendments maybe as an exception, but we just don't have a Congress right now that is motivated to do more on the environment, and I think that's just a political problem. Sorry.
Sorry, I can talk really loud too. I know there are people online. It's better for the recording.
Yeah.
I think one of the cool, right up in there. The Endangered Species Act is one of the limitations, I think, is it's framed around these individual species, right? And often or always they work in ecosystems and that they're central. Could you talk a little bit about Earthjustice's efforts to think about species as part of, I spent a lot of time in Seattle, and I think the salmon was really popular for a while, and then it got kind of a bad rap as sort of the charismatic megafauna where people love salmon, but they're not. But then there are all these really important ecological effects of salmon, and beyond the historical and indigenous importance of salmon, but also you find the nutrients from salmon in trees, right? And so that the salmon coming back in has a whole ecological effect. Yeah. And I'd just be curious how how you think about framing those arguments, because the law isn't necessarily written for that, or how that impacts Earthjustice's work on that?
It's something I think about a lot. It's what drives me in my work, is thinking about an ecosystem perspective rather than a single species perspective. So I'll take my manatee case. We treat it as a case about manatees. To me, it's a case about the Indian River Lagoon, which is a 147-mile estuary. It's the most biologically diverse estuary in North America. It's got the most plants and animals of any estuary. And it's dying because of nutrient pollution. It's a seagrass ecosystem. Everything that is in the estuary basically is based on this ecosystem having seagrass. And so algal outbreaks that cause the seagrass to die changes the entire ecosystem from a seagrass ecosystem to a toxic algal ecosystem. And so when I brought this case, I was thinking about the manatee because that's our legal hook under the ESA, although the case also mentions loggerhead and green sea turtles, which are also protected, and small-toothed sawfish, which is endangered species of fish. But we talk about manatees because people love manatees. They're iconic. But the case and the goal of the case is bigger than that, right? We're trying to solve and save the seagrass ecosystem from total collapse. I also do a lot of Pacific Northwest salmon work. Same thing there. For the dam case, that is a case that impacts those 3 species of fish, but also every migratory fish that goes up and down that river, including coho, which are not listed. So we think about the ecosystem is kind of in everything that we do, for the most part. I think our recovery plan cases may be the exception there, because that's really about how the numbers of the Mexican wolf. But in terms of, and again, the Rock Creek Mine case, that's a case about grizzly bears and bull trout, but also about the indigenous groups that have lived there since time immemorial, and that's their sacred lands. So it's about the ecosystem. Yeah.
Quick follow-up, if that's okay, is like, when you brief these, do you brief the whole ecological impacts? Like, even though the law is pretty specific about what it protects, do you, from an argumentative, I don't know, you're down there in the Fifth Circuit, I'd be curious how you think about it.
I'm not in the Fifth Circuit, I think, ever. Try to stay out of that one. Yes, I think being a good lawyer and an effective advocate is about storytelling. And so where it really is about, this is not just about this one species, it's about the whole kit and caboodle going to hell. We tell that story. You invited me to an animal law conference, so I tried to keep it to the animals, but yeah.
Thank you for being here. And one question, correct me if my understanding of the ESA is wrong, because it probably is. But when you are advocating, when you are litigating under the ESA and saying that EPA or the Fish and Wildlife Service hasn't used the best available science, are you also proposing different science to use, or how do you manage that?
So the best available science standard, it has to be based on what they had in front of them. So oftentimes we help build the record by when there's a comment period, or if they have a proposed rule to list a species and they're asking for comment, we'll have our scientists put in, this is the best available science. And then the litigation becomes, well, why'd you ignore that? And was it arbitrary and capricious to do so? We, for the most part, cannot at trial, or there's not trials in the Section 7 context, but we, for the most part, can't put in new science at that point. It had to have been before the agency. Now, that's a little bit different in Section 9, because that's a trial type proceeding where we have to prove that the person is taking the species, in which we put on experts that say, yes, what you did, your false attraction flows to the dam is a take. But in terms of best available science, no, it has to be before the agency.
Hi. I'm kind of curious about with reintroduction of animals like the grizzly and stuff like that, where it's not a manatee, it's not like salmon, they're not necessarily cute and cuddly, it's like they'll rip your head off, and there's it seems like there's some sort of public pushback in a way that it almost makes it a bigger issue. I feel like with some of the ESA stuff, like environmentalists and maybe people like very specific with the land have like a lot of interest in the matter. I feel like with some of like the grizzly stuff, it's taken on a much bigger salience with people. And I'm kind of curious about the ways that Earthjustice and others in kind of the environmental movement think about communicating why this is relevant and why this is important, despite the fact that like it might increase, even if it's marginal, but like the risk of basically reintroducing a new hazard to humans.
Yeah, so one of the things I love about working at Earthjustice is I'm the litigator arm. We have a communications arm that's quite good. And when we talk about, you know, top predators like wolves, grizzlies, which we do a lot of work on, part of that is communications, you know, helping folks to understand that these are animals that are part of an ecosystem. They were here before we decided to wipe them out, and they should be here still, but for us shooting them all at the turn of the century. And so part of that is communication to the public to help folks understand that, you know, these animals deserve protection and to be reintroduced to their habitat in the case of the grizzlies, which I believe is hopefully coming any day now in the North Cascades.
Thank you for your work and the presentation. I just had a question regarding if you thought in some ways the ESA is actually undermining animal welfare efforts generally, because sort of by design, it is creating a hierarchy of animals we should care about or animals we should protect. And I'm just sort of going off of, we had a presentation yesterday on speciesism, and there seems to be some tension between giving some animals certain protections and other animals little protection based upon how close they are to extinction. Because you could certainly think of, like, maybe, I'm not sure, overpopulation of deer, for instance, that would, going by the logic of ESA, that we would want to eliminate the deer. So it's sort of taking out the whole concept of the animals having value in and of themselves. So I'm just wondering if from your work, you've seen ESA being a roadblock to further advancements in animal welfare.
It certainly isn't just an animal welfare statute. One thing that comes to mind, I talked about spotted owls. One of the major threats to spotted owls is not just habitat reduction, but the barred owl, which is a competing species of owl that outcompetes northern spotted owls. And one of the ways to prevent the barred owl is to shoot them. So there, as part of the ESA protections of the northern spotted owl, it's something that the wildlife agencies contemplate and carry out. You know, as I said at the end, I think the Endangered Species Act has some real gaps because it is only focused on and protecting animals when they're really at the brink of extinction. And even then, you know, you saw our listing fight for the Pacific fisher took 20 years, 20 some plus, maybe 25 years to get that species protected from the point at which we thought it needed protection. So even if you're at the brink, you're not necessarily getting the law's full weight against you or in favor of you. I don't have a good answer to that, except that, again, all y'all smart folks in this room who are going off into careers, think about fixing that for us.
I would also add that the Endangered Species Act can be used to protect individual specimens of a species, especially in captivity. I think Professor Hollingsworth, who runs our clinic, is an expert on that. And one example I would give is the southern resident population of killer whales out in the Pacific Northwest, which are listed as a distinct population segment under the Endangered Species Act. They weren't initially listed that way, but Earthjustice sued to get them listed, and that led to some litigation, which helped a female orca who had been kept in captivity in a tiny little bowl in Miami for 50 years. So I think, like, there are definitely tensions raised, as you mentioned, but if utilized creatively, it can also be a great way to help individual specimens of the species. Yeah.
Hi, thanks for coming. As a follow-on to Michaela's best available science question, I'm wondering, in the process of building up the record and then making these arguments, do you mainly just rely on your own evidence in making those arguments, or do you say if there's other environmental organizations that get involved, use their evidence? And do you ever find there being any conflicts if, say other friendly parties that you work with, or does it generally tend to work out well?
To be honest, my favorite things from the record to point to is the agency's own science. A lot of times they'll write a scientific analysis that shows, I had a case about the California spotted owl where all of their status assessment was like, this owl is gonna die tomorrow. And then they said, but it's fine, we're not gonna list it. I was like, no, your scientists seem to say otherwise. So yeah, if we have good science from anybody, not necessarily, and sometimes we get involved in cases so late that we didn't have time to put our own science in the record, so we're based on whatever's already there.
Thank you for coming again. My name's Adam. I'm curious, you talked a little about Section 4. One of the challenges and limitations of the Act is that Fish and Wildlife Service only has limited funding to list species and designate critical habitats, partly by the nefarious design of Congress. But I was curious how recognizing that reality for a group like Earthjustice and other conservation groups, how do you strategically take into account that, advocating on behalf of the listing of one species is going to hurt the chances of survival of another?
I think that's a hard problem, right? If again, looking at you all in the room and your future jobs, if you can fund Fish and Wildlife Service to have more staff to do more listings, that would be helpful. And there are trade-offs. I mean, what I tried to talk about with the Fisher was it was a concerted strategic effort to pick species that would have sort of wide-ranging value to protect the whole ecosystem. And so there is a strategy to focusing on species that are going to have the biggest impact in terms of not just the species itself, but beyond. And I don't have a great answer except that we need Fish and Wildlife Service to be moving on everything all at once.
Great. Well, thank you so much. Thank you, Elizabeth. Oh.
Please I brought swag from Earthjustice for those of you who are so inspired to put, bumper stickers or take our strategic plan, whatever, and my card. Please take them things so I don't have to drag them back to Seattle with myself. Thank you so much for having me.
Thank you so much. So we're so excited you were here, and now that concludes Animal Law Week. So thank you all for attending. Thank you, Shashank, for moderating. And thank you to our entire audience on Zoom. We had quite a few people. And thank you, Kelly Reddy, our program administrator, for handling all the kinks of all of Animal Law Week. And thank you, Sarah Pickering, for all the media and communications. And all the slides will be available on our website. And until next year.
Yeah.